Thank you for joining us for our OVW webinar on victims' rights for immigration practitioners and advocates. My name is Kelly Byrne. I'm a staff attorney at ASISTA Immigration Assistance, and I use she, her pronouns. I'm grateful to be joined for today's webinar by Erika Gonzalez and Meg Garvin. A few housekeeping matters before we begin. Today's webinar is being recorded, and the recording will be sent to all attendees after the webinar. All materials, including the slides, were emailed to attendees before the webinar. If you don't have the materials, you can please check your spam folder, but if you still don't see them there, you can request them by emailing ASISTA's program associate, Maria Lazzarino, who we have here on the line, and we thank her for everything that she does for us. And her email is in the chat here. This webinar has been approved for 2 CLE credits in Texas. If you are licensed in Texas, we will submit your CLE credits on your behalf. If you are licensed elsewhere, or if you are a DOJ accredited representative, please email Maria after the webinar to request a certificate of attendance to submit on your own behalf. Please ensure that your full first and last name are included in Zoom if you are seeking CLE credit, since that is how we verify attendance. As Mary Kate said, we ask that you please use the Q&A box only for your questions during today's webinar. You're free to use the chat box to interact with each other, to answer our questions, and to voice your thoughts during today's presentation. Finally, we'd like to take a moment to thank the U.S. Department of Justice Office on Violence Against Women for their support of ASISTA's training and technical assistance work. Without OVW's support, today's webinar would not be possible. Next slide, please. So for our learning objectives, after attending this webinar, attendees will be better able to identify the intersections between humanitarian relief and the criminal legal system, to identify strategies to promote victim agency while engaging with law enforcement and other system actors, to identify avenues to protect immigrant survivor privacy while accessing other legal protections, to apply promising practices when responding to subpoenas in an immigrant survivor's information, and to support immigrant survivors in law enforcement interviews and in obtaining restitution. Next slide, please. So we'll start with a discussion of an introduction to victims' rights. Then we'll talk about entry into the criminal legal system, asserting victims' rights and attorney licensure, information sharing. Then we'll transition into a discussion of the Brady versus Maryland decision and subpoenas, attorney attendance at interviews, restitution, and questions and answers. Next slide, please. And Meg, I think this is you.
It is. Thank you. Good morning. Good afternoon. Pronouns. And I am with the National Crime Victim Law Institute, which is based here in Portland, Oregon. Very excited to be joining everyone. From is the Multnomah and Cathlamet, and I'm incredibly grateful to the elders who have let me be on this land and learn and grow on it. And I commit to nurturing it throughout the rest of my life as I live on land. So I get to start us around what are victims' rights. And this is just going to be a very foundational moment to give us some common vocabulary as we move into the long list of things we're going to try and do today. So again, just trying to give us a little bit of a common vocabulary. So the next slide, let's go to that so that you understand where I'm coming from in terms of how I'm describing victims' rights. And that requires you to know who the National Crime Victim Law Institute is. We are a nonprofit. We're based in Portland, as I already mentioned, and we're based at Lewis and Clark Law School. I flag that piece of it because we are predominantly lawyers. We do victim services as legal services and our legal services as victim services. That is really the focus of what we do. We were founded in the year 2000 to fill a gap in the criminal legal system. And that gap was what happens when a victim has to intersect with the criminal legal system. What we knew at the time and still know is that can cause trauma. It can cause trauma if a survivor is on board with what's happening in the criminal legal system. It can cause trauma if they are opposed to it. It causes trauma in part because survivors get lost in the mix and their voices get co-opted. So we were founded to do crime victim-centered legal advocacy, education, and resource sharing around the criminal legal system, and more specifically to ensure that survivors can have their own attorney as they navigate investigation through trial and including post-conviction if a conviction occurs. And that investigative moment is one of the critical moments of victims' rights because the system hasn't fully started acting yet, at least in terms of the prosecutor. So we come with a lens of survivors should have lawyers in the criminal legal system. So lawyers to do what? That gets us to the next slide, which is victims' rights and what are victims' rights. So here's your first engagement moment. There are 3 ways on the screen, and I'll read them out loud for those of you that can't access the screen right now. 3 ways of spelling and punctuating in English the way we talk about victims' rights. The first one is victim apostrophe S rights. The second is victims plural apostrophe rights. And the third is victim with no S and no apostrophe rights. Of these 3, use the chat box to say which, if any of these resonate with you. Which of these, when you think about victims' rights, are the way you think about victims' rights? Is it the singular victim apostrophe S, the plural, or the no S and no apostrophe? All right, we're getting a wide variety here. Some are singular, some are plural, some have an apostrophe, some don't, right? There is no right answer. There's no right answer here, except to have intentionality around the way you are thinking about victims' rights. If you are situating yourself in the first one, victim singular apostrophe S rights, that is about the individual human being having rights. And when they have rights, we have to ask them, what do you want to do with that right? Right? Because they have to either know, this is where I situate myself when I'm working on amicus briefs, right? I'm really thinking as a group, right? Or I might have 2 clients. Sometimes I'm there. The last one, victims' rights, I would say is often, oh, people are having trouble hearing me. It looks like
the audio's
in
going
the
in and
chat.
out a bit.
My internet is showing I'm strong. How would
You try turning your
you
video
like me to
off?
proceed, Kelly?
I
I'm going to
think you
turn
could
off my camera
yeah.
for just yeah, that's what I was just thinking. I'm just going to turn the video off. Okay. We'll see how this goes, and then I'll try and remedy after this part. So the last one, victims' rights without an apostrophe and an S. Victim is really an adjective there, right? It is, okay, it looks like my internet is having trouble. So let's move to the next slide and I'll wrap up here quickly and I'll come back to this. The bottom line is the apostrophe matters. We have to act with intention when we're thinking about victims' rights. We have to act with intention about how are we thinking about the right? If it belongs to the victim, which an apostrophe in Western European and North American English means, it can either mean a contraction or it means ownership. If a survivor owns their rights, no one, not the court, not the prosecutor, not a defense attorney, can act on that right without the victim being involved in the conversation. So next slide, what rights does a victim have an apostrophe over? So many, so many. The ones on the screen are the most common victims' rights that exist in every jurisdiction somewhere in the law. I can find these rights somewhere in every jurisdiction's law. The right to due process, fairness, dignity, and respect, to privacy, to confer, to notice, to be present, to be heard, to speedy disposition or be proceedings free from unreasonable delay, and to restitution. These are the most common rights. And if you click again on the slide, they exist everywhere. So there is a map here. The color coding doesn't mean anything, it's just there for a visual effect that every jurisdiction has something. And you see on the image on the right, which is the tree of rights, that there are some branches that don't have specific rights attached to them. That's because there are so many more. And every year we are looking at how do we find language in law to create additional rights or to have rights recognized. Victims have standing to assert these rights in trial courts across the country, but they need lawyers to help with that. And immigration lawyers, you all see the core moment of this work. And so what we're doing today is talking about. And so with that, I'm going to turn it over to Erika, I think, on the next slide.
Hi, all. Meg, I hope you can get that fixed and let us know if we need to shut off our videos to help your internet too, because we can do that. Hi, everyone. My name is Erika Gonzalez, and Maria, if you could take us to the next slide. I am the managing attorney for the Training and Technical Assistance Department at CAST. I am also located in South Lake Tahoe, California. I know CAST is located in Los Angeles. They assume I'm there. I used to be there, but I'm up north now, and I'm in Washoe land. I want to tell you, CAST is generally a wraparound service program for trafficking survivors. We offer legal and social services in-house. We also do policy work, and I manage the training and technical assistance partner with my colleague Carson Augustberg, who is on the chat as well. We're just a small two-person department, and through federal funding, we are able to offer free training and technical assistance to legal practitioners and social service providers who are working on the legal remedies for human trafficking survivors. We are mainly known for our T-visa work, but we actually do provide TTA on things like victim rights, criminal record relief, trauma-related practices, just to name a few. On your slide, you'll have links to how to access all of that stuff for free. And we've partnered with ASISTA and with NCBLI for a long time, so I'm really excited to be here on the webinar with them. Next slide. And if you could also launch, well, give me a second. We're going to have our first poll. And the question that I'm asking you in this poll is essentially, how do you currently approach UT and VAWA cases? And when you're thinking about how to answer this question, I want you to think, when you are filing particularly a U or a T visa case, do you establish your case as though it's primarily a form of humanitarian relief? Or do you approach it as though it's more of a law enforcement tool? And if you're new and have never filed one, how do you think you would approach it? So Maria, you can go ahead and launch that poll. Okay. The slides will be shared afterwards. I believe, Kelly, you said that they can find that in their email.
Yep, that's right.
Okay, great. I'm going to give 10 more seconds for folks who want to participate. So how do you approach these applications? Okay, Maria, you can go ahead. It looks like the polls stopped coming in. You can go ahead and share the results. Yeah, so we see, and this is primarily true of what I see in practice, that most people, and here we have about 84% of people who approach these visas like a humanitarian form of relief. So if we want to move us to the next slide, and I'll stop sharing this. Oh, get that out of my way. As a technical assistance provider, as we know, and as we've just seen in this polling, many people approach their visas assuming that they are mostly a form of humanitarian relief. However, what I will say is a lot of the language from the Department of Homeland Security, from DHS, especially as it relates to UNT visas, is that the UNT visas are there to strengthen law enforcement's ability to detect, investigate, and prosecute crimes primarily. Like law enforcement use is their primary purpose, right? And this suggests that the intention of the tool isn't just to give someone status, but actually to trigger the investigation to help law enforcement and strengthen their abilities to do their work. And while the VAWA, the Violence Against Women Act, doesn't have the same cooperation requirements, it was created alongside the Violent Crime Control and Law Enforcement Act of 1994. And so these three forms of humanitarian relief are interconnected with criminal law, and that must inform how we approach the way we are engaging with immigrants and helping them to navigate these forms of relief. There is a tendency for people who solely work in immigration practice to approach these cases from like that narrow humanitarian perspective, with the goal of getting the visa and not paying attention to the trail left behind or how you might be entering your client into the criminal legal system. Also, we see that when approaching cases like this, the case strategy often relies on sympathy rather than showing USCIS that the person who is applying actually fulfills the overall goal of the creation of the visa and meets the basic eligibility requirements. This can create issues for clients as the clients committed against them intersect with a lot of different legal systems. And in this particular training, we're focusing on that intersection with the criminal legal system. We often see that the law enforcement component of a lot of these visas are considered secondary components to the entire visa process, and people are just doing it because they have to do it without considering like all the implications of how these visas were created and what their purpose is. Next slide. So I use this visual a lot, and this is to show and highlight the way a lot of the legal systems intersect with each other, right? And particularly when we're working with crime victims. Immigration, we have the T&U visa primarily, but where they intersect with the criminal law is definitely with cooperation with law enforcement and criminal record relief, inadmissibility waivers, and then there are the crime victim rights, but they're interconnected. They're not separate, right? And so we have to understand that there is a push and pull in the way that we are working with each of these forms of relief, even if our primary focus itself is with immigration. Next slide. So I'm going to focus on UNT visas predominantly because they have a law enforcement cooperation requirement, though I'll try to also highlight it when it comes to the VAWA applications. When I was thinking about this presentation, I tried to think of like a visual and how immigration attorneys can conceptualize how they're entering immigrants into the criminal legal system. And so hopefully this visual is helpful. And if it's not, you're more than welcome to give me feedback, because this is what I call one of my shower ideas, where I'm like thinking about this and I think about how to visualize it while I'm shampooing my hair. So I think, again, like taking a step back, because both the U and the T visa have this certification or cooperation requirement, the main way we as immigration practitioners engage with the criminal legal process is by trying to get law enforcement certifications, right? We're trying to get this to fulfill the requirement to show that our client cooperated in the investigation of the crime against them. And usually at this phase, what we're trying to assess is if the crime has been reported and if the crimes meet the basic requirements for cooperation. And what do I mean by that? It's really common in the T visa cases where there was a crime committed, but we're trying to assess if like the trafficking itself was actually reported. So if the client did report, right, I think there are two things that we can acknowledge at this point. Is one, there has been initial contact with the criminal legal system, right? So they've already engaged the system. And then two, there might be an active investigation or one that has already occurred. Okay, so, we're checking that out. And even if the case is closed, I think the other thing we can acknowledge is that we are actually re-entering our client into the criminal legal process because we are asking the criminal legal system to provide something to us. Sometimes that touch can be lighter, like in a U visa certification where we're following procedures that are already set by law enforcement just to get this signed document. But other times we might need to reopen a report to either correct the report, clarify the report, which could mean that we're reopening an investigation. And if the client has not reported the crime, which is the basis of their visa application, then we have to acknowledge that what we are actually doing with our clients is entering them into the criminal legal system. This is beyond just, checking that the reporting requirement was met, but actually we are starting an investigatory process because a criminal report does initiate a criminal legal process. And here, at this point, we must acknowledge that the immigration process and the criminal legal systems are intersecting, and we can no longer operate in a silo. Next slide. So this leads me to present on why reporting strategy matters and why we have to think about it. Again, as I said in the last slide, reporting is the first step in entering the criminal legal system. And what we do know about crimes in general is that there's a funnel effect, right? An upside down funnel, where as many crimes has occurred, only a few get investigated, even less are prosecuted, and even less than that result in convictions, right? So the funnel gets smaller and smaller and smaller and smaller. So we know, based on, especially if you went to law school, this kind of point was drilled a little bit in your head, that just of all the crimes that occurred, even the ones that we're interacting with, so few are going to get investigated. But that doesn't stop us from assessing and understanding what the report does. The report, as I mentioned, triggers an investigation and initiates the criminal process. So it is kind of like an avalanche effect, which is the visual I picked here, is that when a criminal report is made, what happens after that investigation depends on what law enforcement wants to do with it. And often that decision is completely outside of the control of a crime victim. And so once that happens, they really need to, without understanding the priorities of law enforcement, which are dictated by many things like funding, community outreach, and what they're engaging in, all of this is outside of the client's control. And as a result, we have to understand that when we are entering them into the criminal legal system, that there are crime rights or crime victim rights that attach as soon as the crime is committed against them. And many of those rights are automatic and often ignored. And if you look at the NCVLI resource that I linked, you'll see that at the pre-arrest and investigation of a crime victim, the rights that attach automatically at that point are the rights to compensation, which usually happen through a victim compensation program, a state victim compensation program, the right to be treated with fairness and respect, which are really important for people who have been treated poorly by the criminal legal system, the right to information, and the right to support systems or support persons. These rights might vary by state. I love NCVLI's resources on this. This is one of my favorite ones. And I think it's good for you to keep in mind that when you're working with a crime victim, they're coming with these rights already attached. Understanding the criminal legal system also helps us as immigration practitioners to properly inform the client about what it actually means to engage with the criminal legal system. We see many immigration attorneys jump to report the case solely because it fits the immigration requirements and they're trying to fulfill the immigration requirements. And as a result, many clients are uninformed about what happens after they report. And what we have found out in working with organizations such as the National Survivor Network and just talking to other survivors is that they feel pressured or even bullied by their immigration attorneys to engage with the criminal legal system. And so before deciding where or how to report, the client needs to be fully informed about how the criminal legal system operates and their likelihood of further engagement with the process. That means they understand what law enforcement's priorities are or the likelihood of their case moving forward if they have no evidence or if they have a lot of evidence. That being said, I think that it's really important that the client understands that they have a choice in how they're engaging, and that even if they choose not to engage, that they also understand that there is a consequence for failure to report. I'm trying to wait for my dogs to stop barking. Okay, as a legal representative, I think it's also important to understand that you understand how the criminal legal system informs how. Sorry, let me take a step back. I got very distracted by my dogs there for a second. As a legal representative, your understanding of the criminal legal system should inform how that crime is reported and whether you help the client walk in to report, which is not the most trauma informed, or how you request an interview, if you request an interview. And while you might not be representing the client in the victim's right process, at least you set up your client for a better chance of success if and when they have to move on without you. And this is a form of harm reduction for people who have been harmed by the criminal legal system. And Kelly's going to talk to you a little bit more about it, what it means to represent, a little bit about what it means to represent in the criminal legal system. So today we're not going to discuss how to report a crime in this training because that largely is going to depend on the type of crime and the client's goals, which is beyond the scope of this training. CAS does have a guide for our recommended approach on how to report for T visas, including some of the considerations that Meg will discuss in the second half of the training. Sorry, that was a little bit convoluted because of the dogs. This is what happens when you get a puppy. Can I have the next slide, Maria? One thing that I do want to talk about is the impact for pushing for certifications and what this means and how this informs what we do. As national technical assistance providers, I think one of the things we often see is that many practitioners don't actually understand what is the minimum requirement for cooperating and sometimes try to go above and beyond, which can have implications in the criminal legal system. Again, we're not working in siloed. We're not just trying to get the eligibility requirements met. We're entering our clients into the system. And I think one misconception is that practitioners often assume that the cooperation requirement is the same for things like the U and T visa. And while we can acknowledge that the U visa does require certification, there is no exception to that. We also have to acknowledge that the T visa doesn't require certifications and many times doesn't actually increase the likelihood of success. When USCIS put their characteristics of the T non-immigrant status up last for fiscal year 2022, almost 83% of the T visas did not file certifications that were approved. So that's a really important stat for people to know. But because of these misunderstandings of cooperation, we sometimes see practitioners pushing for certification with recklessness by repeating contact with law enforcement and or reporting to multiple law enforcement agencies in order to try to get the certification. And while this can potentially be necessary in U visa cases, there are still underlying implications in continuous engagement with law enforcement. For example, each report to different law enforcement agencies is a potential start of a new case. So that means that each time we talk to law enforcement, we might be starting a new case because we don't know all of their priorities. The other thing is by encouraging clients to report to multiple agencies, we are inadvertently forcing them to engage repeatedly with law enforcement. Do they consent to all the reports? Do they know why they're reporting to multiple agencies? Have they been aware? Have they been given the option to opt out of that? The other implication is that each report generates a record that is not protected by attorney-client privilege and can be used and pulled against them potentially. And each time you engage with law enforcement, it actually does increase the risk of inconsistent statement, which can be used in multiple legal systems to attack the victim's credibility. Inconsistencies, even if they're minor, can severely impact the client's case and overall credibility. So these are all the things that we need to think about in this intersection. Next slide. The last thing I want to talk about is about race equitable representation and victim rights being a core part of this. Understanding that victim rights can be an accessible way to reduce harm acknowledges that the criminal legal system does commit harm to certain populations. And when we're working with victim rights, it does allow victims to enforce rights that they're entitled to. And it is especially helpful knowing that immigrant survivors are often treated without respect. So utilizing the victim rights actually makes them feel respected. And if those rights are violated, if they have representation, then they can feel that someone is in their corner, because prosecutors work for the government and their interest is to the government and not to the victim. I think it's also important to understand that victim rights allows, and considering them and informing them about them allows victims in themselves to make informed decisions about how they engage with the criminal legal system, and if they even want to. Even if they know it's a requirement for the visa itself, we still continue to hear that victims feel pressure to engage through their attorney and often feel coerced to do it. If you don't report to law enforcement, then you won't get that visa. That language mirrors trafficker language and mirrors perpetrator language, and we have to be cognizant of taking that away to allow choice and trauma-informed practice. Also, I will say that when you engage in victim rights representation, it discourages punitive processes from the government, because victim rights can advocate for alternative practices and how they engage with victim witnesses. One of the things that helps with sometimes having representations is it shows the victim's willingness to cooperate and engage. And when they're willing to do that, you can sometimes advocate against punitive approaches by the government to participate, like subpoenas, which can be really difficult when you're working with someone who's highly traumatized. And then finally, I will say that when we're enforcing victim rights, it encourages general trust within the system, because marginalized people are just never going to fully trust the criminal legal system based on the way that it has treated them historically. So by having representation that speaks for themselves, it at least helps to consider some of the trust and safety that could come out of enforcing these rights, and shows that people actually do care about victims and what they're entitled to. I will say that my conversation and my point, a lot of the victim rights details are going to go to Meg at that point. But this isn't meant to undermine that immigration applications have certain requirements and we have to fulfill them. But my point here is to highlight how there is a push and pull of the immigration legal system that we cannot ignore. So I think, Kelly, you're next.
That's right. Yeah, thank you, Erika. Maria, could we go to the next slide? Thank you. So Erika's, really so ably discussed why it's important to represent immigrant survivors and victims' rights matters. But there's this question of who can assert these rights, who can do this representation. Next slide, please. Thank you. So one of the major issues when you're determining who can represent an immigrant survivor in a victim's rights matter is this question of attorney licensure. And as Erika talked about, victims' rights representation is something that you have to be thinking about when you're representing survivors on especially U&T petitions, because like she mentioned, both of them often or always, in the case of U visas, require some form of interaction with the criminal legal system. And that interaction might make victims' rights representation necessary. And as we'll learn in a minute, at least some types of victims' rights representation require that the attorney is licensed in the jurisdiction where that right is being asserted. And many immigration attorneys are not licensed in the jurisdictions where they practice, and that can make it difficult or impossible to provide survivors with the victims' rights representation that they need. And lack of representation can prevent a survivor from asserting those victim rights that Meg had talked about earlier. And this has serious implications for the survivor's safety and their privacy, particularly if this is a case where there is an active investigation. Next slide, please. So for a poll, sorry for the misnumbering, this actually should be poll 2. Maria, if you can go ahead and launch the poll, please. The question is, can you enforce an immigrant survivor's crime victims' rights in state court if you are not licensed in that state? Give it about 10 more seconds. Okay, we can go ahead and close and share the results. Okay, so 70% of you answered no to this and 30% answered yes. So thank you for your participation, and we're going to talk more about this in the next slide. One more, Maria. Thank you. Okay, so if you aren't licensed in the state where you practiced, you won't be able to represent the survivor, at least by yourself, on any victims' rights matters that are in state court. One option, if you do want to start doing this representation in state court, is to get licensed in the state where you practice. Sometimes this actually isn't that difficult, especially if the state where you practice has some sort of a reciprocity agreement with the jurisdiction where you are licensed. In other circumstances, might require a little bit more legwork, might involve taking another bar exam. You could consider talking to your employer about paying the fees for the preparation and the exam, with the justification being that providing truly holistic representation to immigrant survivors who are engaged with the criminal legal system, that is the most client-centered and trauma-informed approach. If you cannot get licensed where you practice, you could consider co-counseling with a victim's rights attorney who is licensed in that jurisdiction where the right has to be asserted. You could also consider referring the case to another attorney within your organization who is licensed in that jurisdiction. If co-counseling or in-house referrals aren't possible, a last resort is to develop warm referral networks of attorneys in the jurisdiction who can conduct both the immigration representation and the victim's rights representation. One thing to consider if you do have to refer the survivor to another attorney, while working with a new attorney necessarily means that the survivor will have to retell some aspects of their story. Minimizing the amount of retelling that the survivor has to do is the most trauma-informed approach. And to help prevent as much re-traumatization as possible, you could consider getting informed consent from the survivor to send their file over to that other attorney, so that other attorney can get up to speed on the survivor's story and with what is happening. And that avoids the survivor having to retell, their entire story to an entirely new person. Next slide, please. If you can't represent the survivor in a victim's rights matter, you'll have to consider whether it's best for this survivor to have one attorney who can represent them both in the victim's rights matter and in immigration. Essentially, the consideration is whether you should withdraw from the case with the permission of the survivor. There's a lot of factors to consider here, and there isn't always like a right answer. It's going to depend on the circumstances. One of the factors to consider is whether there is a high likelihood of investigation. And that partially depends on being familiar with the practices of police and prosecutors in the jurisdiction, like Erika was discussing earlier. It also depends on some factors like, has the statute of limitations already passed on the crime and it hasn't been reported yet? If that's the case, less likely that there's going to be an investigation. Maybe the perpetrator was never identified and the case has been inactive for some time. Or perhaps the prosecutor declined to charge the perpetrator. In those cases, might tip the scales in favor of you keeping the case. But if on the other hand, the perpetrator's been arrested and they've either been charged or charges are imminent, or there's a situation like Erika was mentioning where you're amending the report and that could reopen an investigation, In those cases, an active investigation is much more likely, and that could tip the scales in favor of you withdrawing in favor of an attorney who can do the victim's rights representation. Another question is whether you can inform the survivor of their victim's rights, so the survivor is at least aware of them, even if you're not licensed in that jurisdiction. Whether you can do this is going to depend on that jurisdiction's professional conduct rules. So the place where you practice, what are the professional conduct rules there? Do they consider advising someone on state law to be the practice of law, or is it more limited and that's practice of law is more working it in state court? If you can't even provide the basic information to the survivor about rights that are critical to their safety, that can tip the scales in favor of referring out the entire case. Another question is, has this survivor already developed a strong bond with you? Are they very comfortable with you? If that's the case, might not be the most trauma-informed approach to sever a connection that might be a source of safety and stability for that survivor. But that's less of a concern if you've just accepted the representation and haven't worked as extensively with the survivor. Another really important factor is whether there's other immigration attorneys in your jurisdiction who are language accessible, trauma-informed, affordable, and culturally competent. If there really aren't many others and immigration representation is important to the survivor, that could be a reason for you to keep the case, even if you can't do the victim's rights representation. More likely that there's not going to be many other immigration attorneys who can do the survivor-based work in a trauma-informed manner if you're in a small jurisdiction or in a more rural area. But if you're in a large city with a lot of organizations that can do survivor-based immigration work and that have attorneys who are licensed in that jurisdiction, that's less likely to be a problem. Another factor is whether there are co-counsel opportunities. So if you can associate with another attorney who does the victim's rights representation, that allows the survivor to assert their victim's rights with the assistance of an attorney without having to completely sever their relationship that they have with you. And then related to this question of co-counsel opportunities are there common interest privilege laws in this state? There are some articles in your materials index about common interest privilege that I encourage you to take a look at if you're interested. But really generally, it allows attorneys whose clients share a common legal interest to be able to share case documents with each other without compromising attorney-client privilege. And as Erika was talking about before, ensuring that privilege isn't broken can be really important. Next slide, please. And now we're going to talk about information sharing, and that implicates a victim's right to privacy and potentially to fairness and dignity. Next slide, please. So this slide, it contains some important considerations on information sharing. The first is that any information that is shared with law enforcement or prosecutors, and that includes victim witness advocates who work at the police department or who work at the prosecutor's office, any of that information can potentially be shared with the defense. And the reason for that is because of a Supreme Court case called Brady versus Maryland, which requires the government to turn over information in its possession to the defense if that information is considered exculpatory, which essentially means that it could be favorable to the defendant. Brady is a really important aspect of a criminal defendant's rights, and it's taken really seriously. So you need to advise the survivors who you're working with on the implications of sharing information with law enforcement or with prosecutors. That includes the benefits, potentially. It could help them get U or T status, but also the risks that this information that we're sharing with law enforcement, there's a very likely significant chance that it could be shared with the defense. And if that information is private and the survivor doesn't want the defendant to have that information, as trauma-informed attorneys, it's important to honor the survivor's wishes and not to share that information. It's also important to advise survivors, as Erika was discussing earlier, that the very act of just making a report opens up the possibility of a criminal investigation and prosecution of the person who harmed that survivor. And you need to make sure that the survivor is okay and has given informed consent to that possibility before you initiate any type of contact with law enforcement. And Erika said, a lot of this already better than I could, but just repeating that, like, this should go without saying. But an attorney should never force a survivor to share information or to engage with the criminal legal system. As Erika was saying, survivors may be understandably wary of the system for many reasons, because of the systemic racism that's inherent in the system, the trauma that's often involved with being a victim in the system, and negative experiences that some survivors may have had with the system in their country of origin that they've brought with them here to the US and that color their perception of the system here. Whatever their reason is for not wanting to get involved, that's okay. And as client-centered, trauma-informed attorneys, it's important to honor those wishes. It's also, of course, part of your job to explain the consequences of declining involvement. So perhaps, not getting a U visa or not getting a T visa, if you can't meet one of the cooperation exceptions. But we can't be enforcing survivors to engage with the system just because we think it's important for them to get immigration status. Next slide, please. So for our third poll, the question is, should you share a draft declaration with law enforcement when you're requesting a U or T certification, keeping in mind that, like Erika was saying, T certifications aren't actually necessary and don't carry significant weight. So not always a very good reason to be seeking a T certification, but just if you were seeking one, should you share that declaration with law enforcement? And Maria, could we launch the poll, please? Give it about 15 more seconds. Okay, we can go ahead and close and share the results. Okay, so a very large majority of you said no, 92%, and 8% said yes. So next slide, please. So some information sharing practice tips, sorry. So one of the most critical questions that you need to be asking yourself in the information sharing space is what is the survivor's goal here? And that should be driving a lot of the decision making. Common goals might be meeting the reporting requirement for T status, which again doesn't actually require a certification, amending an existing police report, or getting a U visa certification. If the survivor's goal is to meet the reporting requirement for T status, make sure that you review CAST's toolkit that Erika talked about, which is in your materials. If what you're trying to do is meet the reporting requirement for T status, sharing a survivor's draft TGLIT declaration that contains, all sorts of information Beyond just the fact of the trafficking victimization, that's not necessary if the goal here is to meet this reporting requirement. If the goal is to amend an existing police report, which you might do to make it easier to get a U visa certification or to make things more intuitive to USCIS, you want to share only what is necessary to get the charge on the report changed to a U visa qualifying crime. So that would be confined to what are the elements of that qualifying criminal statute and what are the survivor's facts that meet those elements. Sharing an entire U visa declaration is unnecessary to that because there's a lot of information in that declaration that just has nothing to do with, does this meet the elements of this crime? So that would also it would be unnecessary to share the declaration in that case. If the survivor's goal is to get a U visa certification based, for example, on domestic violence, sharing let's change gears, sharing, say, a therapist's letter that details their mental health treatment, that's unnecessary to establishing what you need in order to get that certification, which is showing that the survivor suffered, domestic violence as defined by this jurisdiction, has information about that crime, and has been, is being, or is likely to be helpful. Often state laws, they look at the relationship between the parties when they're determining whether conduct is domestic violence, not whether, the survivor suffered mental harm that was so severe that they needed mental health treatment. Mental health treatment is more relevant to substantial abuse, which is not part of the certification. And providing mental health treatment information to law enforcement that compromises the survivor's privacy, and it opens the door for them to put extraneous information in the certification, which could harm the U visa application if it's inconsistent with other information that's in that filing. So I'm hoping that this kind of goes to show that the answer to that poll question is no. It's not a good idea to submit a draft declaration to law enforcement when requesting a U or T visa certification because it's just not necessary to many of the goals that the survivors you're working with have. And it often compromises the survivor's privacy and can be, submitted to the defense. And there's probably a lot of really sensitive information in there. A good rule of thumb when you're thinking about what information to share is to ask yourself, what's the function of sharing this information? And that's why there's that graphic here on your screen. If you really don't have a good answer to what is the function, what is the purpose of me sending this information, that's probably a good indication that you shouldn't be sharing it with law enforcement or with the prosecutor. Some different questions arise when you are the one who's being asked to share information. Some of the questions that you'll want to ask yourself in these cases are listed here on your screen. Whether there is a victim's right to assert in the situation can depend on the jurisdiction, what stage of the case are you in, who is requesting the information, and then what's the scope of that request. And how you assert that right can also be circumstance specific. So in some cases, maybe you can do some informal advocacy with the party that's requesting that information. In other circumstances, you might have to file a motion in court. If only informal advocacy is necessary, it'll depend on the jurisdiction's professional conduct rules, whether you can do that informal advocacy if you're not licensed in that jurisdiction. If you're representing the survivor in their immigration filing, there is a possibility that you can represent them on conversations that impact that filing, including potentially some of this informal advocacy. If you do need to assert a right in state court, though, if a motion does have to be filed, Remember that you can't do that alone if you're not licensed in that state. And if you aren't licensed there, you need to be thinking about some of those considerations that we talked about earlier. How can the survivor's rights be protected? And is it really best for you to be the attorney in this immigration case? It's best to be mindful of the possibility of these situations before you decide to accept the representation. And it's most likely that most foreseeable that victims' rights representation will be necessary in state court if there's already an active investigation. So that's just something to be thinking about when you're deciding whether to accept a case for representation. Next slide, please. So now it's time to share in the chat. What are some examples of information and documents that should not be shared with law enforcement or prosecutors? And feel free to put your thoughts in the chat box. I'm seeing medical or therapy records, inadmissibility issues, mental health and school discipline records. So while folks, locations, right, if it's not safe to disclose it, anything that could expose the client to criminal liability, declarations, information about other pending forms of relief. Yes, these are great. So just going through some of these, we talked a little bit about why mental health records are not good to submit. They often contain like very sensitive information about a survivor that's just often not necessary to meeting the goal of either getting the certification or meeting that reporting requirement. Also, if they're turned over to the defense, they could be used to attack the survivor's credibility in court, which could be, very traumatizing. Regarding inadmissibility issues, definitely, that is also something that could potentially be used to attack the survivor's credibility in court, and really just is not relevant to what you're trying to get here. Medical records, similarly, also probably not necessary. The only time, and you'd want to talk to the survivor about, is it worth the risk of the defendant getting them to send the medical records? The only time that they might be relevant is if you're trying to say that a crime was qualifying and you need to demonstrate that the survivor suffered a certain degree of injuries. So if it's like you're trying to say this is felonious assault because this person suffered really serious injuries, that could potentially be a reason to submit medical records. But those cases are probably, few and far between. Anything that could expose the client to criminal liability, that's a really good one. We want to be keeping an eye out for that. Information about pending forms of relief. Exactly. I can't see any reason why you would want to, why it would be necessary to talk to law enforcement about that. And again, that could be, turned over to the defense and used to attack the client's credibility. Declarations, also not good to submit. There's a lot of really sensitive information in there that could be used against the client in court. I really liked this one that someone put about locations and another person, children and family members. And those are good reasons to not submit entire immigration applications. Some attorneys wonder if they should submit like the entire U visa filing to law enforcement. No, right? Because often we need a 192 waiver for U visas, and that contains really detailed information about someone's location, about where they work, about their family members. So just not necessary to submit that to law enforcement. So thank you very much, everybody. Next slide, please. This issue of criminal history and U visa certifications. This can be especially relevant if the agency that you intend to ask for a certification they often refuse to certify if the survivor has a criminal history or they might, if they require some sort of explanation or rehabilitation evidence before they'll certify. The first step in these cases is to consider other certifiers. Of course, keeping in mind the necessity of, maybe in that case, the survivor has to engage with another system, which you'd want to, think about, does that make sense? And as Erika was talking about before, but if the survivor has engaged with another system, like the Department of Labor or Child Protective Services, remember that those agencies can also serve as certifiers, and they might not have, these policies that are so strict about criminal history. If this agency, though, is truly the only certifier, you could first request that certification without providing any criminal history information. And that's probably the best approach. If they request an explanation or some sort of rehabilitation evidence, to approach this from the lens of victims' rights, you're going to need to consider is there a way that you can assert a victim right to counter that request? If there's an active investigation, the right to privacy is often implicated if there's a party to a criminal case who's asking a victim for information. How would you assert that right? There might be informal advocacy opportunities with that requester. If there's not an active investigation, your question is, does this right to privacy, does it vest at an earlier stage of the process? Did it vest at the time that the victim experienced the crime? Or if the case has ended, is the right still active because maybe the case is on appeal or the defendant is pursuing post-conviction relief? So those are questions you'd want to ask. If the right to privacy for some reason is not implicated, what about the right to fair treatment? When does that start and when does it end in that jurisdiction? And could you frame this, really intrusive request for information about the victim's criminal history? Could you frame that as a violation of the right to fair treatment? So these are questions that you want to be asking yourself when you get these requests for criminal history information, when you're asking for a certification. Next slide. So I think we're going to pause for a few minutes for any questions that came up. I'll look at the Q&A first, because again, those are easiest for us to see. Erika or Meg, were there any that you wanted to start with?
I think there are a couple that we can tackle in this section. The first one is Meg, you're getting into Brady a little bit later, right? A little more, I think so. So that one
I will, yeah.
Yeah. So I think this question then, is it good practice then to have less DOJ reps to deal with UNT visas? It's probably a good one in this section. Do you want to start, Kelly, or do you want me?
You can start.
Yeah, I think this question about whether it's good to then have less DOJ reps to deal with UNT visas is a little bit of a complicated question, in the sense that, like, there aren't enough attorneys to represent crime victims in and of itself. So I think one of the practices that is really important in organizations that are reliant on DOJ accredited representatives is to assess the criminal component and to assess what is the likelihood that this case is going to be investigated, such that then you can make a decision whether you are the best person to represent or not, or whether that case should go to a DOJ representative. Like, for example, if the case is 20 years old, then like the chance of a law enforcement investigating is a lot lower, but that doesn't mean it's zero. Right? Especially in trafficking cases where some jurisdictions like to have the reports and like to have an interview to keep a track of perpetrators. The chance is never really zero. Like, it can get close to zero, but it's not really zero. Meg, I saw you kind of nodding. Did you have things you wanted to add?
I completely agree with your analysis. And the one thing I always add to the analysis too is, like, who might be, what do you already know about the representative, and what do they know about DOJ guidelines for all federal employees to uphold victims' rights? because there is a mandate on all DOJ employees to do best efforts to ensure that rights are meaningful, which would mean if it triggers an investigation, the representative would have a duty to ensure that law enforcement is also abiding by their duty. So you can kind of, if it has to go that direction, or if that's the best option, remind people gently and sometimes not so gently about their obligations under the law themselves to afford victims their rights.
Kelly, do you have additional thoughts?
I don't think so. I think you two covered that really well.
Let's see. I think a couple of these might be addressed in Megan's section. Yeah, some of these are a little specific. Let's see, what about this question? You mentioned being aware of whether or not you are licensed in the state where you are practicing in order to engage in victim rights, but what about accredited representatives?
So I think in that case, the question is accredited representatives, like they wouldn't be able to file a motion in court because they're not because they're not a licensed attorney. In terms of asserting victim rights in other settings, I think what Meg said is really relevant here.
Meg, can you talk? Because I think the way that I hear this question often is like, what if the DOJ accredited representative helped in reporting, but then law enforcement asks for an interview? What are the ways that the DOJ representative can engage in victim rights enforcement?
So I think what they can do is a handful of things, right? They can, so asserting rights can happen in any venue, meaning like you can do it through an administrative moment, you can do it in an informal moment with law enforcement, you can do it through the formal assertion through motion practice in court, right? So in a law enforcement interview or a request for an interview, a non-barred attorney in a jurisdiction as well as a representative can flag that rights exist and can, in the moment like of a question intruding on a right, simply note that victims have a right to privacy. Just as the way a victim advocate who sits in on a law enforcement interview is not engaging in the unauthorized practice of law when they say, we're going to take a break from this interview, or when they say, I think a victim has a right at issue here, or a victim has rights in general, you have to simply know each jurisdiction's line of what crosses over into the unauthorized practice of law. It varies a little bit, but there's actually a lot you can do even as an advocate, let alone a barred attorney from another jurisdiction or a representative. So it comes down to learning what constitutes unauthorized practice of law in each jurisdiction and what moments are intimately related to your representation such that you actually, as Kelly noted, weave it under the umbrella of your existing representation as an immigration lawyer or as a representative. So I think there's a lot that can be done, but answering it like, yes, you can and no, you can't, would not do justice to knowing, right, the ethics of each jurisdiction.
And Meg, it looks like the interpreters are having a little bit of an issue, so would like you to get a little closer to your phone when speaking.
I'll hold it up to my mouth, everyone.
Let's see. Yeah, I think the other ones are, I guess this is maybe one other one we can answer is, can criminal defense attorney, I feel like that's going to be answered in Brady though, right? Can criminal defense attorneys get information from USCIS about the U visa application, like the survivor statement? I think you'll cover maybe some of that in Brady.
I will cover some of it, but it won't specifically cover USCIS because USCIS falls outside of the Brady coverage specifically. What I will say is, right, there's different confidentiality, federal provisions of confidentiality over what is with USCIS. You can absolutely fight requests for victims' information that is in USCIS's possession because they would be violating separate federal regulations if they disclose it, other than to, in certain moments, federal prosecutors. I'm going to put in the chat something that I did not include in the materials in advance, but this is a link to a blog post that NCBLI has on its website, which includes a link to our amicus brief as well as a court order about discovery of certain underlying information, where the defense was trying to get it directly from the victim, saying you have to disclose what USCIS has. So it's a little adjacent to the question, but it gives all the arguments of why information in the possession of USCIS is outside of what's discoverable.
Yeah, and I think folks should also take a look at the 1367 guidelines on privacy and disclosure from USCIS. They just released the policy manual explanation, which I'll add in the chat as well. I think we have a hand raised. I don't know, Mary Kate, are we doing hand raised questions in audio like that?
Can if you would like, but it's up to you.
I know we have a break coming up, but I'll let Kelly decide.
I would say if you can type it, the question, that would be better. But if you're unable to, we can accept the audio question. I think we'll take our break here, and that person, you know, when we come back, if you still have that question and you want to ask by audio, that works. So I think next slide. Okay, so we're going to take a 5-minute break. So come back at right now it's 3:12 on the East Coast. So wherever you are, come back at 17 when it says 17 on your clock. So take a 5-minute break and then we'll be back. Okay, I think it's just about time to get started again.
Ellie, before we get started, can I check my microphone sound? As I know that was having challenges.
It's going in and out a bit.
It's kind of
I'm
quiet.
going to try calling in again.
If you have headphones for your phone, that could help if you called in and then connected your phone to headphones. Sorry.
So I'm trying again, Kelly.
Sounds good to me.
It's too quiet and too far away for the interpreters to interpret. If you have headphones you can connect to your phone, that would work.
I actually have headphones in, so it's still not working.
I don't think so. We'll see.
Meg, just scream about victim rights because they're important.
Can the interpreters confirm?
They haven't
Okay.
yet, but they can't hear it still. It's not.
Okay. Kelly, since this is your show, how would you like me to proceed? I can speak incredibly loudly if that would be of assistance.
I think you could try that.
Okay. I will try that, and if it doesn't work, then we will pivot again. I apologize, everyone. I've tried a handful of things. So what I'm going to talk about now, if we could go to the next slide, is a little bit more detail on criminal discovery. So both Kelly and Erika have hinted at this, plus all of the questions have really hinted at this, which is, what are the obligations, what are the laws governing when information sharing has to happen in a criminal legal system? And this slide is called criminal discovery, but I want to put a footnote on that. When it comes to a survivor, the word discovery would be in quotation marks. And what I mean by that is they're not subject to discovery. So we're going to move on to the next slide to unpack discovery just a little bit more. Starting though with a little bit.
Meg, sorry, the interpreters are still saying they can't interpret. Do you have notes maybe that Erika or I could read?
Let me try one last thing
Okay.
and see if that works. Interpreters, could you try one more time and tell me if you can hear me? Interpreters, would you type, is that better? I see one that says it's better, but I don't know if that is an actual official interpreter.
That's not an interpreter. They say not enough.
Not enough for interpreting. So Kelly, I have the notes in the slide deck that was originally shared, but I don't know if you have them. I certainly trust both you and Erika to fully understand Brady and privacy. So can turn it over to you all.
Erika, I think you might be more qualified on this than I am.
Oh God, to try to be Meg is something else. Can you oh, I have to get the notes from the original slides. I'm sorry, folks. Technical difficulties always arise. Do I know Brady? I do know Brady, but do I know it like Meg knows Brady is the next question.
I can type some notes into the chat if that would be useful as we go. The other alternative would be to go to the questions and answer those, because they really unpack all of Brady. And I think in answering those, I could type my answers while you two give the other information.
Let's see. Kelly just sent me the slide deck, so we're going with the flow here. Your notes are definitely a little bit more sparse than I think I could go on. So why don't we go ahead and just jump to the questions for now, and then let's start there. Let me see what slide they are. Meg, did you have specific questions that you were going to ask, or were you just talking about questions generally?
I was speaking of the questions from the attendees.
Okay, let's see. Okay, so I think the first question that I saw about that kind of addresses Brady is, what is the risk of sharing additional brief information about the victimization on a cover letter when requesting a T or U visa? And I think when you say brief information, I'm hoping if you put in the chat box, the person who answered this question, what you mean by brief information. Because when I think about reporting and how you report, generally law enforcement needs a little bit of information in order to know what to proceed with. Specifically, they need to know what type of crime is being reported, and generally they need information about the perpetrator. I think where things start getting complicated when you're disclosing to law enforcement, because remember, the conversation that you have with law enforcement is not protected by attorney-client privilege, is the information that you share there with the facts. Anything there is going to be subject to Brady. And Brady really gets at the obligation of prosecutors to disclose any information that could be exculpatory against the accused, so that the accused has a right to confront that. And if the factual information is inconsistent and that information gets in the hands of the accused, that can be used to attack the client's credibility. This is under a case called Giglio, Brady and Giglio, or Giglio. I've looked up that pronunciation of that friggin' case like a million times and heard it pronounced both ways. But both of those are considered potential exculpatory evidence to attack the credibility of a witness. So the risk of sharing additional information is it creates an inconsistency, a potential risk of inconsistency. Kelly, do you want to add anything? And also Meg, in the chat, if I explain that okay, will you let me know?
I think you did that really well. Just that, however you pronounce that case, is about like impeachment evidence, and then Brady about exculpatory. Thought that was great.
Maybe we can jump a couple slides, Maria. Because I think I really like this visual that Meg has created, and about looking at what discovery looks like in a criminal case. I'm pretty sure if we start with looking at just what information can be shared, we really some of this is not only dictated by the Brady and Giglio cases that we talked about, but also by states and the rules, right? And so who has access to this is the state, and criminal defendants can get access to information. And there is rules that explain this, and as Meg is typing in the chat box, it explains what discovery is under the law, and the federal rules 16 and 17 in each jurisdiction, or sorry, rules 16 and 17 in each jurisdiction govern what must be disclosed, and these are obligations are only on the prosecution and the defense. Yeah, thanks, Kelly. Yeah. All right. Let me pick another question. I think that's helping us. Thank you for writing with us here. This question, I think, gets close to that. Does Brady trump 8 USC 1367 and other laws protecting privacy? Kelly, you want to take a stab? Or you want me to?
I think there hasn't been like any, as far as I'm not aware of any definitive case law that answers that question. To be completely honest, I think it might, because it's like a constitutional, it's part of the constitutional right to confrontation. So I think that there's a potential that it could.
Yeah, the hard thing about with any of these privacy rules is a lot of them are based on what the judge decides at the end of the day. We have heard anecdotally of quite a few cases where because Brady is part of the disclosure components, but also there are constitutional rights for the defendant. And the judge is weighing often the victim witness's right to privacy with the defendant's constitutional rights to a fair trial and to disclosure. So I think it's really important to understand that a lot of these are based in arguments, and we don't know until we're in the courtroom and disclosing them. And I see that Meg has also added, I see Maggie has pointed out too that like part of the difficulty in these conversations is like, who is part of the state, and as Maggie added, definitely victim witness advocacies that are located in prosecutor's office are part of the disclosure, like of the prosecution and part of the government. So to anyone on the law enforcement team, there are fair game for that Brady obligation to the defense. And a lot of crime victims think they can openly talk to victim witnesses. That's not true. And Meg added to that the next slide. I like moved the next slide on my note slide, but Maria, can you add one slide? Meg is adding that this slide shows that anyone who falls under the Brady obligation, and that a rule is that anyone and anything under the possession and control of the prosecution is bound by Brady laws. So that includes law enforcement-based victim advocates. Those might be called victim witness advocates in your state. Prosecutors, prosecution-based victim advocates, they all fall under Brady obligation. So anyone who the victim witness is talking to that isn't their own attorney or victim rights attorney and works for the state falls under that. And Meg adds that the squiggly line with community-based advocates demonstrates that sometimes they have been deemed to be part of the state's control team because they work so closely with prosecutors. I've seen this anecdotally to be true, or to have those arguments in situations where there are multidisciplinary teams, particularly task forces that are funded all together. I think to add to that original question of does Brady trump 1367 and other laws protecting privacy, Meg adds that to my point about the defendant's rights, one key is that the right to confrontation is a trial right, so that cannot be a ground for pretrial access to victim information. Thank you all for rolling with these punches. Let's see. Okay. Let's see. First question. Oh man, I don't think Meg, I can get into the motion to quash. Kelly, you want to? I have to.
I can try. I can try. We can go to the next slide. So this is just like a checklist of key arguments for a motion to quash a subpoena. The first is standing. So Meg had talked about in in terms, and that she's saying that they have templates for almost every jurisdiction that they can share. So thank you for that, Meg. In terms of the question of standing, that is, why is this victim even allowed to file this motion? And the reason that they are is because as a crime victim, they have standing to assert their rights in court. The second is the federal constitutional right to privacy, and that is a right that the victim has, and then that's a key argument to make when you're making a motion to quash a subpoena, is that the information that's being requested is a violation of the victim's constitutional right to privacy. Statutory privileges, so perhaps some jurisdictions have like therapist privileges or community-based advocate privileges, like domestic violence, sexual assault advocate privileges. So if one of those is implicated, like for example, a DVSA agency is being subpoenaed for information about the victim, it would be important to assert those privileges in the motion. Meg's talking about oh, and then on the constitutional right to privacy, Meg makes a great point about even after the recent Supreme Court decisions on abortion, which, in some cases have undermined this constitutional right to privacy, she's still saying that informational privacy is intact at the federal level. So that's a really important point. Thank you, Meg. And then the additional statutory protections that you'd want to include in your motion are any statutory rights to privacy, VAWA and VOCA confidentiality, so agencies that are funded by the Office on Violence Against Women or through the Victims of Crime Act themselves have federal confidentiality obligations regarding information that they receive from the victims they work with. So those should absolutely be included in any motion to quash a subpoena that is being filed by a domestic violence sexual assault agency, or for example. Meg also makes a great point about constitutional protections against search and seizure of private information and personal property. Those do apply to victims of crime. We traditionally think of them as being applied to defendants because that's usually where they show up in case law, but they do absolutely still apply to victims as well. And right, just like Meg said, it's not just an accused right, it's for everybody. And courts have recognized that that's a great point, that there's state action and court orders for information. The reason why state action is important, because often to assert that there's a Fourth Amendment violation, you have to say that it was, a state actor who was requesting the information, as opposed to, maybe like a private attorney for the defense. But Meg's saying that courts have recognized that if there's court orders for information, you have that state action there, and you can assert that Fourth Amendment violation. And then this is a really great one here, that the defendant has no constitutional or statutory rights to pretrial discovery of the victim's privileged information. So that's also really important to include in these motions. Next slide, please. So this slide on having a survivor-centered mindset and being ready on Brady and discovery, consultation and partnership with the is really important. When you're working, the prosecutor you're working with, it's important to learn their interpretation of Brady, because not all prosecutors' offices have similar interpretations. Some think that, just the very fact of a request for a U visa certification is itself Brady material. Others, think the actual certification document is what is Brady material. So it's important to have a sense of how they interpret Brady. It's important to be communicating with the prosecution to ensure that you, as the victim's rights attorney, are part of pre-review of Brady materials. So you have advanced notice of the materials that will be shared with the defense, so you can prepare your client for that. And then taking direction from your client as well. Brady is very complicated. You can have, probably multi-day training just on Brady. And it's important to be familiar with how it's interpreted in your jurisdiction, and what will and will not be considered Brady material within your jurisdiction. Erika, did you have anything else on that?
I think that's yeah. I think that's good for
Okay.
now. I think that this is also just generally important to cover the Brady stuff and understand what it is, because I do think a lot of prosecutors and law enforcement then try to have conversations with the client, the victim witness directly, and not know what's going on behind the scene. So having your own knowledge to be able to inform the client allows your client to make more informed decisions on that direction that they want to take.
Could we go to the next slide, Maria? Thank you. So law enforcement and prosecutor interviews. Next slide. So this is just here. This position paper is actually in your materials from NCVLI about how crime victims have the right to retained counsel's presence during investigative interviews. And I think that this actually responds in part to one of the questions that we received. I think it might have been in the Q&A about what do you do if law enforcement refuses to allow the attorney to be present in the interview.
Yeah, this one, and Meg, maybe a little bit of a spoiler alert, but NCBLI has been working on updating this tool as well with more recent case law on it. But I think that part of understanding this client's right to counsel in an interview is also part of the advocacy component of why it's important to understand the victim rights tool, because law enforcement, and I've been in many of these situations where they feel that your presence there as an attorney actually interferes with their ability to do what they call an investigatory interview, to try to make sure that the client answers all of their questions. And a lot of state laws do allow for representation. And one of the things that, and I always cite to this right to counsel piece by NCBLI, is that without the right to counsel, the victim rights can't be asserted, or makes it harder to be meaningfully asserted. And as Meg is adding in the chat, law enforcement officers and prosecutors will often ask you to stay out of the interviews or intimidate you or your client into not being present. And it's so important to recognize that in this moment, counsel for the victim is just like counsel for the accused. You being in the room helps to protect them with so many different of their automatic rights. I find particularly the right to be treated with fairness and respect, and having you in the presence allows for that. Kelly, you want to add anything?
I don't think so. That all made perfect sense to me.
Meg,
Thank
are we
you.
covering your slides okay?
You're doing amazing.
Okay, great. The next topic, let me see. Wait, I think there was a follow-up question in this one before we move on. Since the interview isn't covered by attorney-client privilege, is it possible that an attorney who is present during an interview during an interview could be called as a witness? And I'm gonna let Meg Meg type in there the solid answer. But the answer is not only yes, but also your notes sometimes can end up being discoverable. So it has to be you have to be really careful in how you take notes in those interview. And that is absolutely true, and so can a defense attorney and a prosecutor. So I think, Meg, what you're trying to say is that also defense counsel and a prosecutor can be called as witnesses.
Yes.
Okay, I'm just making sure that I'm interpreting your chats correctly. And I definitely remember that the bulletin covers this. I read that PDF all the time. So I think it's really worth for you to note what your state's victim rights laws say and fully understand how they're written about the representation. Some states are more clearly state that the assertion of victim rights requires and allows for the representation. Other states, it's a little bit more ambiguous, which is why this document that NCBLI created is so helpful. And Megan Meg added it in the chat. The bottom line is that anyone in the room could be called as a witness. It simply rarely happens because of the other protections for attorney-client relationships. I think I'll add that again, these are still arguments to be made, and why also you have to be really careful about how you're participating in the interview and what notes you're taking, and just like what is being collected at that point. Kelly, anything to add?
No, really excellent points.
Let me see. I swear I saw another one that was related to this. Well, let's go back to Brady. There's another Brady question here before we get into restitution. Can the mere request for a U visa certification be considered Brady material?
It depends, I think, on how that prosecutor's office interprets Brady or that jurisdiction. But I do think in some cases it can be. Meg's saying the fact of application is generally considered Brady.
Yeah. And I've seen definitely anecdotally the fact that there was a request for certification sometimes comes in there. Some of this is, again, up to the judge at the end of the day to decide. The application itself is protected from discovery unless it is given to the prosecutor.
So that's why you want to try to not give it to the prosecutor if at all possible.
Yeah, I think we can cover restitution.
I think so.
Let's move to the next slide. Do you want to go ahead, Kelly?
Sure. So there's different avenues of financial recovery for crime victims. From there's state crime victim compensation programs, and they are principally reimbursement based, and they don't require prosecution of a case. Typically, they only cover violent crimes. It's going to depend on the state's law, what types of crimes are covered by the victim compensation system. There's restitution, which comes from the criminal justice system. And then there's the civil justice system, where the victim could sue the defendant for civil monetary damages. And then there's a lower burden of proof associated, obviously, with a civil lawsuit than there is within the criminal justice system.
Yeah, on that victim compensation is one of the most underutilized I see as like something that is actually pretty accessible to crime victims and can be easily applied to. And I think it's really like this is one of the ones that victims really need to be informed in how they can get financial support to cover some of their injuries, including sometimes like emotional or mental health issues where they might need therapy or other stuff that can be covered under victims compensation programs. Also in California, for example, for trafficking survivors, there now is a way to recover loss of wages to a certain extent, where you don't have to then enter formally the criminal justice system or the civil legal system. So not knowing that this is an option tends to really be a disservice to a lot of crime victims. And as Meg is saying, compensation doesn't require prosecution at all. Sometimes it does require a report in certain states, but certain crime victims might have an exception to that. And Meg added that crime victim compensation exists in every state and has a relatively simple application process. Did you want to add?
Yeah, I definitely agree with that. I used to practice in Delaware, and yeah, the simple application process, definitely the case. The paralegals in our office would often meet with the victim, and that, just in one day, help them fill out the application. In Delaware, I think it wasn't even necessary to report the crime. I think if the person received like a domestic violence protection order, that would also be a way that they could get crime victim compensation. And I'd say probably most of the clients I worked with, they were able to access therapy because of crime victim compensation. So very, very important tool, as Erika said.
Someone said, wonderful, or Meg said, wonderfully, the VOCA guidelines are being revised right now, and the move will be to create more accessibility and recognition of challenges to reporting for many communities. And OVC has issued guidelines for comment. Next slide. In this slide is a quote from NCBLI's advisory council members from a survivor that they worked with. She was shocked about not knowing anything about restitution until sentencing. I'm going through the restitution process now, so now I am trying to collect information. Someone should have discussed restitution with me earlier. I was not told to save receipts. I had some documents, but the task of managing life was challenging enough, so the last thing on my mind was documenting expenses and saving receipts. Now I need to think backwards, so the question is it worth it, especially if we won't see a penny? Meg adds that she was part of our working group to create a restitution log to help victims learn to track restitution from the beginning. I find restitution to also be really interesting because it very rarely is asked for, even in plea bargains, and in some states, especially depending on what the crime is, the restitution is a required component of it. In plea agreements as well, like even if they're pleading for lesser crimes than what was committed, for example, in trafficking, if they're pleading, we often see something less like harboring, they can still write the restitution and the mandatory restitution into plea agreements. So I think it's really important to highlight this quote and understand that damages can be compensated through the criminal legal process and through prosecution. And Meg has shared a log in the chat for how victims can learn how to log their restitution, their expenses in order to get restitution, which sometimes can be a really complicated process to do. Let me see. Are there questions related to restitution? Don't see any. Okay. Next slide.
So on this slide, just it's bringing home the fact that restitution is very broad in terms of what can be covered. That's kind of conveyed here with the graphic. It's part of sentencing, and so it has two different goals, both compensatory goals, so making the victim whole from what happened to them, but then also penological goals, meaning it's part of the penalty the defendant has as part of their sentence. It is a right, and it is mandatory in numerous jurisdictions, as Erika was saying. Often victims don't get restitution, even though it is mandatory, and part of the role of victims' rights attorneys is ensuring that you're asserting that right to restitution. And Meg was saying, even immigration attorneys who can't be victims' rights attorneys, you could still have a role here in helping victims start tracking their expenses that they have, and sharing those with prosecutors. And that kind of gets to the concern that the survivor had shared in the previous slide about not knowing until sentencing that this was, something that they should be doing, that they should be tracking their expenses as early as possible in the criminal process. Having your survivor clients, working with your survivor clients to help them track their expenses, working with them on that restitution log that Meg put in the chat could be enormously helpful. It's important to know which losses can be part of restitution, because that will vary. And again, just think big in terms of what the victim can get out of restitution. Did you have anything else, Erika?
No, and the next two slides are related to a case law, which I know NCBLI has resources on the restitution, on case law restitution questions. There was a question in the chat about it, is if someone is compensated through the state, can they still ask for restitution? There is an interplay with restitution and crime victims and crime victims compensation. That is what I do have to refresh my memory on. Meg, do you have anything that you can add for that? She says, yes, you can recover both compensation and restitution, just not for exactly the same items. Yeah, that's my gut reaction to it, but definitely something to double check and look into. Maria, if we want to go ahead, these are all case law or crime laws on restitution and when they're mandatory or not. So we can go ahead and Meg said we can go ahead and move to the wrap up. So you can go ahead to the takeaways.
I think, yeah, a couple more. One more, I think. Thank you, Maria. Okay, so just the takeaways that we want you all to have to leave with this webinar. Certain forms of humanitarian immigration relief, they can't be separated from their intersection with the criminal legal system. Victims' rights representation is a way to reduce harm. As Erika said, it's a form of harm reduction for marginalized clients as they're engaging with the criminal legal system. Any information that is shared with law enforcement or with prosecutors will likely be shared with the defense. And because of that, share only the limited information that is necessary to achieve the survivor's goal. Victims' rights can help protect clients' privacy and safety before, during, and after criminal cases against harm doers. And restitution is a key right for immigrant crime victims. And Meg is being very generous in saying that if people have questions that have not been covered, please feel free to email her, and she put her email address in the chat. And Erika's just reminding folks that slides have already been shared to people who registered for the webinar. They were shared yesterday. If you don't have that email, check your spam, but if for some reason you still didn't receive it, you can reach out to Maria, and I'll put her email again in the chat. Yeah. Next slide, please. I think we've answered most of the questions. I saw a question from a little earlier about how do you deal with cases like domestic violence when the police arrive and the victim is afraid and does not cooperate. This is very common, and we included therapist reports justifying this reaction. I was wondering if you have some feedback or other ideas. So I think, I'm not sure if the question is how do you deal with it in terms of requesting a certification, or how do you deal with it in terms of the immigration application. In terms of requesting the certification, I don't think it's necessary to include like a therapist's report to justify why the victim was afraid to report. I think you can confine it mostly to arguments about the helpfulness requirement, not requiring the victim to press charges. A lot of departments use that language and forget that ultimately the decision of whether to bring charges belongs to the state. So just because a victim has, said that they do not want to press charges, that doesn't mean that they haven't been helpful. So I think emphasizing those arguments. And then also, I think it's not necessarily something you could do, but it's also kind of putting the onus on the law enforcement agency or the prosecutor to create the conditions of safety that the victim needs in order to feel safe enough to cooperate. The question shouldn't necessarily be, is the victim being cooperative? The question should be, have these agencies done everything in their power to make things safe enough for this victim to be able to come forward?
Meg is also typing another answer. I did see
Awesome.
a question too that I think that we could answer here. Where'd it go? What are the best practices for responding to subpoenas? For example, for the client immigration case or for for example, a subpoena for the client's immigration case file or for the client's U visa application. And I'm assuming that this means for if a practitioner is being requested with those information. My first advice is if you don't know how to deal with the subpoena, is to make sure that your agency or your firm also has representation in this kind of area, for them to make the argument of why you don't need to respond to the subpoena. It's not always sufficient to be like, no, I'm an attorney, right? That doesn't always work. Meg is answering that question. Additionally, Kelly, do you want to add some more points?
I don't think so. I think what you said is really important about having representation for subpoena defense. Often, sometimes that can be accomplished pro bono. Some advocacy agencies already have partnerships with pro bono attorneys who they could work with to respond to those subpoenas.
Waiting for Megan's answer. I'll just say for the purposes of interpretation, for the DV question, for NTVLI, our practice is that if the victim wants prosecution but doesn't feel like they can participate because of fear, then we would authorize sharing some of the information, although not actual therapist report itself, but perhaps a summary. If a victim is choosing not to participate and in fact also doesn't want things to move forward, then I, as their lawyer, would not want to share anything. So for me, as a victim rights attorney, the first question is, what does my client want to achieve? While Meg is typing up her answer, Kelly, I also saw another question for CLEs and whether they should report on their own. I know you touched on that in the beginning, so perhaps it's worth answering right now.
Yeah, sure. So if you are licensed in Texas, ASISTA will take care of the CLE reporting. If you're licensed in another jurisdiction, what you could do is email Maria, who I'll put her email in the chat again, and ask for a certificate of attendance. And then you can submit that on your own behalf to your CLE accrediting agency.
And it looks like Meg added to the subpoena question. She said, agree with Erika's point in having agency policy is critical. In addition, the key is knowing what your client wants. So step one in a policy is notifying the client. And step two is then to move to quash if the client does not want to disclose. And again, in the NTVLI slides, there was a checklist on for the motion to quash, if I recall that. Right, the checklist of key arguments. I think we're at time, Kelly.
I think so. I think so too. Thank you everybody for bearing with us, and thank you to both Erika and Meg for sharing your expertise. Definitely couldn't have done this without you, and thank you to Maria for moving the slides, and to TA. Hope you all have a great afternoon.
Thanks, folks, and thank you for your patience. We really appreciate you.
Bye, everybody.